Good morning, Your Honor. Candace Mann on behalf of the people, P80652.
And good morning, Your Honor. Danian Woodson, P68870, on behalf of Ms. Pruitt, who is standing to my left. Ms. Pruitt, please state your name for the record.
Jessica Pruitt. Good morning, Ms. Mann, Ms. Bradley, and Ms. Pruitt. So this case is scheduled for 10 a.m., but I'm calling it now because all parties are here. An issue as to whether the parties want to settle this matter. And we have a jury that is waiting, called to the courtroom. Now, I understand after having a sidebar discussion with counsel, Ms. Pruitt, that you want to proceed to trial, but you want a new lawyer. Is that right?
That's correct. We have not spoken one time one-on-one about this case. I don't feel like I've been represented at all. I've not been guided. I've been kind of doing it on my own. She's great. I like her and everything, but I need somebody who's going to see what I'm talking about,
Did she review the discovery with you?
She sent it to me in an email. We've never spoke about anything.
You didn't discuss it with her today?
At this point in the hearing, the judge is laying out something extremely important. The jury is already waiting. That detail might seem small, but in the legal world it carries major weight. When a jury has been called and is ready to begin a trial, the entire courtroom is operating on a tight schedule. Jurors have taken time away from work and family, the attorneys have prepared their arguments, and the court has already invested significant resources into getting to this moment. So when a defendant suddenly raises concerns about their attorney at this stage, the judge has to carefully evaluate the request. On one hand, every defendant has the constitutional right to effective representation. On the other hand, courts cannot allow last-minute delays without a strong justification. What the judge is trying to determine right now is whether this request for a new lawyer is a legitimate issue of representation, or whether it's simply coming too late in the process to stop the trial from moving forward.
Okay.
No.
You didn't discuss the offer today?
No, not the offer again. The last offer that she told me, I said no to.
So you're saying that you have not spoken about the case with your attorney this morning?
No, at all, period. Throughout this whole process. I've wrote emails stating my concerns and she's emailed me back. But we've never got to discuss the actual, event of what led up to this.
Well, we've had 1, 2, 3 final conferences. And
That's
you are
correct.
telling me now.
Now this statement from the defendant is a serious allegation. Claiming that you have never had a one-on-one conversation with your attorney about your case raises immediate concerns. Normally, a defense attorney will review the evidence, explain the charges, discuss possible defenses, and go over plea offers with their client before trial begins. However, the judge is already signaling some skepticism here. The court starts asking questions about whether the discovery was reviewed and whether communication happened in other forms, such as emails. In modern legal practice, communication doesn't always happen face-to-face. Attorneys often send evidence electronically or discuss details through written correspondence. So the judge is trying to determine whether the defendant truly had no meaningful guidance, or whether communication did occur but simply wasn't in the form she expected.
Now,
Well,
after 7 hearings, that you had not spoken to your attorney?
Is
that right?
Yes, that is
Does that
correct.
make sense to you, Ms. Pruitt?
Well, I gave the benefit of the doubt. I was
It's
hoping
actually-
that she would surprise me.
No, just a moment.
I don't know.
Just a moment.
I-
Just a moment.
Uh-huh.
It was really a rhetorical question
Okay.
because it doesn't make sense.
Well, it doesn't.
It doesn't make sense that you would stop talking. It doesn't make sense that you would not have advised the court that you hadn't spoken to your lawyer in 7 hearings.
Right. I
Now,
understand.
what she did or didn't do is a different issue. But I have to find strict necessity to avoid manifest injustice to adjourn or reschedule.
This is where the judge really begins to push back. The court points out that this case has already had 7 hearings before today. That's a crucial detail. Each hearing would have been an opportunity for the defendant to raise concerns about her attorney if she truly felt unprepared. From the judge's perspective, waiting until the morning of trial, when jurors are literally waiting to be called upstairs, raises serious questions about timing. Courts have to maintain efficiency, and postponing a jury trial at the last minute can disrupt the entire schedule of the courtroom. That's why the judge mentions the concept of avoiding manifest injustice. In legal terms, this means the court must decide whether continuing the trial today would actually be unfair to the defendant, or whether the request for a new lawyer simply comes too late.
Schedule a jury trial on the day of trial when all of the preparation for your trial is made before today, and there's a jury that is at this moment waiting for me to call them from downstairs. So do you intend to hire an attorney?
I do.
Okay, how long will it take you to do that?
I'm not sure. It won't find one today.
So how long do you think it would take you to engage an attorney?
Maybe a week or so.
I can't have a maybe. You know what your finances look like. How
Okay.
long will it take you?
A week.
If it would take you a week to get an attorney, then you really didn't qualify for court-appointed attorney services, did you?
Well, yes, I did. I will figure it out. I mean, there are ways to make
Ms.
it
Pruitt, your case needs to be tried or your case needs to be settled. Either way, you need to have an attorney.
I understand.
And
Notice how the judge now starts focusing on practical details, specifically how long it would take the defendant to hire a new lawyer. This question isn't just procedural, it also touches on another legal issue. Court-appointed attorneys are typically provided to defendants who cannot afford to hire private counsel. So when the defendant says she might be able to find a lawyer within a week, the judge immediately starts questioning how that would work financially. If someone can realistically hire a private attorney that quickly, it raises questions about whether they truly qualified for appointed representation earlier in the case. Still, the judge chooses a middle ground. Instead of forcing the trial to proceed immediately, the court considers giving the defendant a short period of time to secure new counsel, which helps protect her rights while also keeping the case moving forward.
I don't want to set a date for no reason. I need you, and this is my third time asking you now, to give me a date where you can be confident that you can have an attorney of your choice whom you pay for standing beside you. How long will it take you to do that?
A week.
Okay. So we'll come back in a week. We'll schedule the jury trial at that time when you have a new lawyer. And just so you know, Ms. Woodson, I'm going to be looking into the allegations that Ms. Pruitt made today. They're very serious, and I cannot let them go unaddressed, especially because it appears that it is requiring the delay of a jury trial. 9 a.m. Make sure that you tell your new attorney, Ms. Pruitt, of the date.
Okay. Thank you.
Thank you. We're off the record. We'll see you then too, Ms. Woodson. You're not discharged.
I understand, Your Honor.
Good morning again, counsel. And Ms. Pruitt, please state your name again for the record, ma'am.
Jessica Pruitt.
Thank you. Thank you for coming back so quickly, Ms. Pruitt. When you left, I had another.
Now the judge realizes something important. The attorney accused of poor communication hasn't had a chance to respond yet. In the legal system, fairness requires that both sides of a dispute be heard before any conclusions are reached. So the judge calls the parties back into the courtroom and gives the defense attorney an opportunity to explain her side of the story. This moment is critical because allegations about lack of communication can impact a lawyer's professional reputation. As the attorney begins speaking, she explains that communication did occur, but mostly through email due to issues with changing phone numbers. She also describes attempts to contact the defendant and schedule discussions about the case. What we're seeing here is a classic courtroom situation where two very different interpretations of the same events are presented, and the judge must decide which explanation seems more credible.
Other sidebar discussion with counsel, and I realized while I was made aware that I did not give Ms. Wooden an opportunity to respond to your allegations. So I'm going to do that now. Ms. Wooden?
Yes, Your Honor. The court instructed me at sidebar earlier today to call to find out exactly where Ms. Pruitt was, how far away she was, and if she was interested in the offer. at which point I stepped out into the hallway into the conference room and I called Ms. Pruitt, asked her how far away she was. She said she was on Grand River. I said, Grand River what? She said she was 8 minutes away. Then I asked her about the offer again. We discussed it. I explained to her that even if the narcotics were found to be not hers, she's charged with 2 felonies. And based on her behavior in the body cam footage, the resisting and obstruction charge was likely to happen. I also explained to her, when the officers told you to stop, you were supposed to stop. When you don't do that, that is failure to obey a lawful order. When you continue to thrash around, that's resisting. We had that discussion this morning. She said she wanted an attorney who believed in her, at which point I asked her if she wanted a new attorney, and she said yes. At that point, I went out in the hallway. I looked for the prosecutor. I explained to the prosecutor what happened. Shortly after that, Ms. Pruitt came into the courtroom. We asked for approach, and there we are.
So
I'll admit that Ms. Pruitt has changed her phone number. I just got an email from her this morning with the new phone number, and that's the phone number I used to call her when the court instructed me to call her. We have communicated primarily through email because the phone numbers that I have from Ms. Pruitt keep changing. We were supposed to discuss this case on Monday at 2:30. The phone number I had for her then, I didn't receive an answer. That's the same phone number I texted her at this morning at 7:45 to tell her we were in Judge Green's courtroom. At 9 o'clock, I decided to email her to ask her if she received my text. She said no. She thought the court date was at 10. That's when I reminded her. I told her 8:30. That's when she told me about child care stuff in the email. And that's when she emailed me her new number to say that I can't remember, she said she lost her phone and her phone was broken.
okay, so her allegation that she's never spoken to you about the case is technically accurate, but you've had communication with her via email is what you're saying.
Because of the lack of phone communication, because of the inconsistencies of the phone numbers, I have spoken to her before and after every court date. I have also worked with the prosecutor to try to make this offer as favorable as possible for her. We had agreed to not only dismiss the resisting obstruction, but to allow her to plead to 7-4-11 on the possession charge and to do it as a no contest plea.
What's the offer, Ms. Mann?
Your Honor, the offer is for the defendant to plead to a reduced charge of count 1. It would be reduced from controlled substance possession of methamphetamine to attempt possession of methamphetamine, which reduces it from a 10-year felony to a 5-year felony. In exchange, the people are agreeing to dismiss count 2, police officer assaulting, resisting, obstructing, with a sentence agreement of 2 years probation, substance abuse evaluation and treatment as directed, anger management, 40 hours of community service. The defendant is eligible for a sentence under 333.7411, and the people would have no objection.
Now the conversation shifts to the plea offer, and this is a huge moment in the hearing. According to the prosecutor, the state is offering to reduce the original charge from possession of methamphetamine, which carries a potential 10-year felony, down to attempted possession, which significantly lowers the potential penalty. Even more important is the mention of 7411 status. This legal provision allows certain first-time drug offenders to complete probation and treatment without ending up with a permanent criminal conviction on their record. If the defendant successfully completes probation, substance abuse treatment, anger management, and community service, the charge could eventually be dismissed. That's why the judge calls the deal exceedingly generous. In many cases, defendants seriously consider offers like this because going to trial and losing could result in far harsher penalties.
And then any other terms or conditions or fines that would be set by the court.
After hearing from your lawyer, who's an officer of the court, by the way, so I don't need to put her under oath. Anything that she tells me is the equivalent of being under oath because of her status as an attorney.
Okay.
So this is what you're not going to do. You're not going to talk while I'm talking.
Okay.
I said that when you were before me earlier, but you still seem to think you can talk while I'm talking.
I'm sorry.
It's hard because you need anger and impulse control management. That's why. Control yourself.
Okay.
This offer is exceedingly generous, especially the 7411 component. And although I have never done it, if you go to trial on this and you are convicted, I will be sentencing you with the fact that you had no defense in mind. Do you understand? Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, the court downstairs does say
And
that.
we don't have permission to address the court.
Now I understand.
Your Honor, would the court entertain a motion to withdraw?
No, no, because she doesn't have a lawyer right now. But I will at the next hearing.
Okay.
She might under oath.
Ma'am? Call her back here. Ma'am,
And you can stand right up here.
Right here.
Yep.
who are you?
I am Jessica's mother.
And your last name be Pruitt or something else? What's your
Something
name?
else.
What is it?
Walls. WALLS.
Thank you. Ms. Walls,
Yes, ma'am.
you're welcome to be in this courtroom anytime that you are in the area, for that matter. This is a public space.
I'm aware.
You can- I understand why your daughter interrupts people
I
while
knew
we're
you were going
talking.
to say that. Yeah.
Yeah,
Go ahead. I'm sorry.
you can't help it, can you?
I can't help defending myself when I feel like my rights are being violated. That's right. I simply was stating a fact that on the board downstairs, it does say 10 o'clock. I didn't take a picture of it,
Miss-
but I just wanted to make you aware of that.
Ms. Wall?
He said I
Ms.
needed
Wall,
to say it to
Ms.
him.
Wall, you have to stop talking. That's the way it works.
I see.
I would like for you to be welcome in this courtroom anytime your daughter is here before court.
The final moments of this hearing take an unexpected turn when the defendant's mother begins speaking from the courtroom gallery. While courtrooms are public spaces and family members are allowed to attend hearings, spectators are expected to remain silent unless the judge specifically invites them to speak. When the interruptions continue, the judge becomes increasingly frustrated and eventually decides to ban the mother from returning to the courtroom. Situations like this highlight how seriously judges take courtroom decorum. Maintaining order is essential to ensure hearings remain fair and focused on the legal issues at hand. At the center of all this is still the defendant's decision about how to move forward, whether to accept a plea deal that could avoid a permanent conviction or risk going to trial where the stakes are much higher. If you found this courtroom moment as intense as we did, make sure to like the video, share your thoughts in the comments, and subscribe for more real courtroom breakdowns and legal analysis.
If you are disruptive once more in my courtroom, you'll be banned. That's why I brought you back to tell you that. Do you understand?
I understand.
Thank you.
All right.
Am I able to speak now?
I would
No.
like to. To help.
We're slating the church. It's.
Ms. Wall? Ms. Wall?
You really want to entertain my motion, Your Honor?
No, I will not. The apple certainly doesn't fall far from the tree. I just wanted to tell you, you are not welcome back. Don't come back to my courtroom. That's it.
All right, now you can leave.
Have a good life.
I advise you not to say anything on the way.
And you're welcome to view on YouTube anytime your daughter has a hearing.
Walk away in jail.
Have a good day, everyone. See you next week.
Have a good day.
I apologize in advance.